There are sentences that, once spoken, cannot be taken back. Not because the law won't allow it, not because no attorney is skilled enough to reframe them, but because the truth of a sentence, the thing it reveals about the person who said it, is already in the room before the words finish landing, already in the air, already heard by everyone who needed to hear it. I've spent years studying the moments when people in positions of authority forget where that authority actually comes from. When someone who has been given power by a system turns around and tries to tell that system where to go. It happens more than most people realize, and it almost never ends the way the person expects. There is a particular kind of blindness that develops in people who have held power for a long time without being seriously challenged. It isn't arrogance in the simple, obvious sense. It is something quieter and more dangerous. The gradual process by which accountability stops feeling real, where the structures designed to check your power start to feel like formalities, like rituals that apply to other people, like inconveniences that someone with your track record shouldn't really have to sit through. That blindness has a way of revealing itself at the worst possible moment. This is the story of one such moment. The man and the county sheriff, Dale Macon, had been the elected law enforcement authority of Hardin County for 11 years, 3 terms. He won his first election with 62% of the vote, riding a campaign built on promises of toughness and efficiency. In the early years, he was not a bad sheriff. That's worth saying clearly, because this story isn't about a man who was always corrupt. Macon was a former deputy with 20 years of field experience, genuine knowledge of his county, and the kind of direct communication style that plays well in rural jurisdictions. He got things done. People trusted him. But trust, over time, does something complicated to people who aren't careful with it. It can become an assumption, a background condition, something so constantly present that you stop questioning whether it has been earned recently or simply accumulated from years gone by. And when that happens, the distance between a public servant and a person who believes the public serves them can close quietly, gradually, until one day something happens that makes the distance visible all at once. Dale Macon had been in office long enough that he had confused longevity with permanence, long enough that the county felt on some level like his. Not in the legal sense, he knew better than that, or he should have, but in the felt sense. The intuitive sense that develops when a person has walked the same hallways for over a decade and begins to feel that the hallways are an extension of themselves rather than a space they have been entrusted with. That confusion between the power you have been given and the power you believe yourself to possess is the seed of what happened next. The complaint and the record. The case that would expose Dale Macon had been developing for nearly 2 years. Hardin County's jail had become the subject of a federal civil rights monitoring process, triggered by a formal complaint filed by the county's public defender's office. The complaint was specific and serious: overcrowding beyond safe capacity, inadequate medical care, and a solitary confinement protocol being applied far beyond any reasonable disciplinary standard. Multiple detained individuals and their families had provided sworn statements. The documentation included reports, photographs, and medical assessments accumulated over months of careful, patient work. By the time the process reached a federal magistrate judge, the record was substantial. That judge was Patricia Wen. Judge Wen had been on the federal bench for 14 years. She was methodical, thorough, and known in legal circles for a quality attorneys described in nearly identical terms. She was impossible to intimidate. Not because she was aggressive, but because her preparation was so complete that attempts to deflect or obscure simply didn't find purchase. She had read everything. She remembered everything. And she asked questions that demonstrated both in ways that left no room for evasion. Sheriff Macon had been notified of the hearing well in advance. He had 2 experienced lawyers from the county attorney's office. He had been briefed on what to expect. None of that preparation seemed to have reached him in the way it needed to. The hearing. He arrived communicating, before he said a single word, what he thought of the proceedings. He was in uniform, not unusual and not inherently problematic, but the manner in which he carried himself into that federal courtroom was the physical language of a man who had decided this was a formality he was required to perform, rather than an accountability process he was required to engage with. He greeted his attorneys like a senior executive arriving at a meeting run by people who reported to him. Before Judge Wen had even entered, he had commented to one of his attorneys, audible to the court bailiff, later referenced in the record, that he didn't understand why this required an in-person appearance when it could have been handled with a letter. Judge Wen entered. The room rose. Macon rose with it, but barely. A half-second delay that communicates volumes. The hearing opened with Judge Wen laying out the framework, the compliance questions, the timeline, the documented concerns, speaking clearly and methodically for approximately 12 minutes. During those 12 minutes, those in the gallery noticed Macon checking his watch, murmuring to one of his attorneys, and at one point, exhaling with the visible impatience of someone enduring a presentation they have already decided isn't worth their time. When the opening framework concluded, the county's lead attorney began to address the overcrowding questions. Macon interrupted him. Not loudly. He leaned forward and said, in a voice audible in the front gallery rows, "Tell her we've addressed this already. We sent the report in March." The attorney stopped. Judge Wen looked up. "Sheriff Macon, did you want to address the court directly?" What crossed his face was something specific and revealing. Not hostility exactly, but the expression of someone who had decided, below the level of full conscious thought, that the person speaking to him was somehow beneath him in a way the formal architecture of the room didn't reflect. "I'm just saying we submitted documentation in March. My office has been cooperative throughout this process. Your attorney will have the opportunity to address the March submission," Judge Wen said. "I'd ask you to allow counsel to proceed." Macon sat back. Not the way a person sits back when they have accepted a correction. The way a person sits back when they have decided the correction isn't worth engaging with right now. Escalation. As the hearing moved into its second hour, focus shifted to medical care. Specifically, incidents in which detained individuals had reported symptoms that went unaddressed for days. A man who had reported chest pains for 3 consecutive days before seeing any medical personnel. A diabetic woman whose insulin schedule had been disrupted for an extended period. These were not abstractions. They had names in the monitoring report. Judge Wen had those names. When the county's attorneys were asked to address the medical response protocols, their response was incomplete. The lead attorney acknowledged gaps in the documentation and requested an opportunity to submit supplemental materials. Before Judge Wen could respond, Macon spoke, not to his attorney, but directly to the judge. "Judge, with respect, my office runs a facility with a limited budget and a staffing situation that nobody in this building seems to want to acknowledge. We are doing our best with what we have, and I think this process would be a lot more productive if the people reviewing it had some understanding of what it actually takes to run a county jail." The room went still, not with gasps, with the particular weighted stillness that settles when everyone present recognizes simultaneously that a line has been crossed, a line that was clearly visible, that the person crossing it cannot claim they didn't see. Judge Wen set her pen down. She looked at Dale Macon with the focused, complete attention of someone who has been waiting for a specific thing to reveal itself and has just watched it do so. "Sheriff Macon, this court is not reviewing your facility to make your work more difficult. This court is reviewing your facility because there is a documented record indicating that people in your custody, people who are legally under your care, have experienced conditions that may constitute violations of their constitutional rights. That is the subject of this hearing. Not your budget, not your staffing preferences, the constitutional rights of the people in your jail." She paused. "Do you understand the distinction?" His jaw tightened. I understand it. Good. Then I'd ask you to let your attorneys do their job and I'll do mine. The sentence that could not be taken back. A recess was called. During those 18 minutes, the gallery observed a tense, low-voiced exchange at the defense table. The lead attorney leaning in with visible urgency, Macon sitting with arms crossed, and the expression of someone receiving advice they have no intention of following. When proceedings resumed and moved to the solitary confinement section of the report, Macon reached out and placed his hand briefly on his attorney's arm, stopping him mid-sentence, and addressed Judge Wen directly. I need to say something. Go ahead, Sheriff. What followed lasted approximately 90 seconds. He had been elected by the people of Hardin County to run law enforcement. His mandate came from those voters. The federal oversight being conducted was, in his view, an overreach of federal authority into local governance. The people of his county had given him a job to do, and no federal review process was going to tell him how to do it. He finished with all due respect, Judge, you work for the same taxpayers I do. We all answer to the same people. The silence that followed was the longest of the entire proceeding. There are two kinds of silence in a courtroom. The silence that is empty, a room waiting for what comes next, and the silence that is full, the collective recognition that something has just become irreversible, that whatever this hearing was going to be before that sentence was spoken, it is going to be something different now. This was the second kind. The education Judge Wen sat with that sentence for a visible, deliberate moment. Then she looked back up at Dale Macon. When she spoke, her voice had not changed in temperature or pace. It had, if anything, become more precise. Sheriff Macon, I want to make sure the record accurately captures what you just said, so let me repeat it. You stated that this court works for the same taxpayers you do. That is incorrect, and the incorrectness of it is not a matter of opinion. It is a matter of constitutional structure. This court derives its authority from Article 3 of the United States Constitution. It does not answer to local electorates. It answers to the law. The review being conducted here is lawful, it is authorized, and it is not optional. She paused. I also want the record to reflect that in the course of this hearing, you have interrupted your own counsel multiple times, made comments directed at this court that bordered on contemptuous, and most recently suggested that federal oversight constitutes an overreach into local governance. That characterization is legally incorrect. But more importantly, it suggests you may have fundamentally misunderstood the nature of these proceedings. Another pause. Let me be direct. This court has the authority to issue binding compliance orders. It has the authority to fine parties in contempt. It has the authority to escalate this review to the district court level with recommendations that carry significant personal consequence for you. None of that depends on your agreement with the process, and none of it is affected by your electoral mandate. She looked at him steadily. I would strongly encourage you to speak with your attorneys during the next recess about the difference between the authority you were elected with and the authority currently present in this room, because they are not the same authority, and behaving as though they are will not end well for you. The recess that followed lasted 45 minutes. The person who walked back into that courtroom afterward was visibly different. The posture had changed. The executive energy was gone. He sat straight, looked at the table, and when addressed, answered in short, direct, appropriate terms. He did not speak out of turn again. What remained? The compliance review concluded with formal findings. Judge Wen issued a binding order requiring specific changes to medical protocols within 60 days, monthly documentation reviews for 1 year, and an independent compliance monitor. The order also noted, in formal but unmistakable language, that the sheriff's conduct during the hearing had reflected a misunderstanding of federal oversight authority that the court found concerning. That language is in the public record. It will remain there permanently. Macon did not seek a fourth term. His statement cited personal reasons, standard departure language that communicates nothing and everything simultaneously. People who had watched his career understood that the decision had been made for him, in the way decisions are made for people who have publicly revealed something about themselves that cannot be unrevealed. The compliance order was implemented. Medical protocols improved. The man with the chest pains and the diabetic woman had their situations documented permanently in the federal docket, their names attached to a record that outlasted the career of the man responsible for their care. The lesson: Dale Macon was not lying when he said he worked for the taxpayers of Hardin County. In a real sense, he did. But he had made an error that people in positions of elected power sometimes make when they have held that power long enough for accountability to feel theoretical. He confused the source of his authority with the limits of it. He understood correctly that voters had given him a mandate, and from that correct understanding, drew the incorrect conclusion that the mandate was total, that it superseded other forms of authority that were equally real and, in this context, constitutionally superior. Judge Wen's authority came from a lifetime appointment under Article 3, a system specifically designed to be insulated from local political pressure, so it could review local conduct without being contaminated by the same pressures that created that conduct in the first place. That design is the architecture of accountability, the mechanism that allows the law to look at the people exercising power in its name and say, "This is not acceptable, and here is what changes." What she did in that courtroom was not primarily about winning an argument. It was about making sure the loss was complete. No ambiguity, no interpretive wiggle room, no version of events in which Dale Macon had made a defensible point, and she had overreacted. She eliminated those versions systematically on the record. That is what genuine authority looks like when someone else tries to claim it. It doesn't shout. It doesn't escalate. It clarifies. It makes the situation so precisely legible that no one present can leave the room uncertain about what just occurred. Records matter. They outlast the people they document. And somewhere in the permanent record of that federal compliance proceeding, on a day when a county sheriff arrived believing the room would defer to him, the court reporter's transcript captures exactly what happened when it didn't. Word for word, every sentence, including his.